Good afternoon, everyone. Today I will talk about international AML standards and Hong Kong regulatory regime for licensed moneylenders. Regarding international AML standards, let me first introduce two international organizations. The first one is the Financial Action Task Force. We call it the FATF. It comprises of 39 major economies of the world, which you will see from this table. China and Hong Kong are members of the FATF. The FATF is an intergovernmental organization which sets global standards for combating money laundering and terrorist financing. It conducts peer reviews of member jurisdictions regularly to assess their compliance with the international AML CFT standards under a mutual evaluation process. Hong Kong has been a member of the FATF since 1991. The second organization that I would like to introduce is the Asia Pacific Group on Money Laundering, the APG. It was established in 1997 and consists of 41 members' jurisdictions. Hong Kong is one of the founding members of the APG. The objective of the APG is to ensure that the international AML CFT standards of the FATF are adopted and effectively implemented by individual members. You will see from this slide the image of the front cover of a document called the FATF Recommendations issued by the FATF. It contains 40 recommendations of the FATF which relate to AML CFT. The FATF will from time to time update the 40 recommendations, and the latest version was updated in March this year. A copy of the document could be downloaded from our website. The recommendations that are relevant to licensed money lenders include Recommendation 1, assessing risks and applying a risk-based approach, which is contained in Part A, Policies and Coordination. For this recommendation, you may also refer to Chapter 4 of our Guideline on Compliance of AML and CTF Requirements for Licensed Money Lenders, which is the AML Guideline. The main idea of this recommendation is that licensees may consider factors such as country or geographic risk and product or service risk in order to assess the MLTF risk of an individual customer and take effective action to mitigate their risk. By adopting a risk-based approach, licensees can allocate resources in a most efficient way with proper priorities so that the greater risk receives the highest attention. The other relevant recommendations are contained in Part D, Preventive Measures. They include Recommendation 10, Customer Due Diligence, Recommendation 11, Record Keeping, and Recommendation 20, Reporting of Suspicious Transactions. Hong Kong has completed a mutual evaluation in 2019. The whole process of the mutual evaluation lasted for more than 1 year. In about October to November in 2018, the assessment team of the FATF came to Hong Kong for an on-site inspection. At that time, the assessment team had meetings with different departments of the Hong Kong government and also representatives from the trade, which includes those from licensed money lenders. In September 2019, the Mutual Evaluation Report of Hong Kong was published by the FATF. Hong Kong's AML CFT system has been assessed to be compliant and effective overall. Hong Kong's system is particularly effective in the areas of risk identification, law enforcement, asset recovery, counter-terrorist financing, and international cooperation. and Hong Kong is the first jurisdiction in the Asia-Pacific region to have achieved an overall compliant result. The mutual evaluation report contains some recommended actions specifically for licensed moneylenders, and they include the following. First, moneylenders should deepen their MLTF risk understanding, especially in relation to cross-border financial flows, non-resident customers, and politically exposed persons, PEPs, and apply mitigating measures commensurate with the MLTF risk. Secondly, moneylenders should strengthen their controls in relation to customer due diligence, particularly with regard to risks exposed by non-resident customers, and enhanced CDD for foreign PEPs and targeted financial sanction. Thirdly, moneylenders should strengthen their transaction monitoring systems and ensure adequate, appropriate, and timely reporting of suspicious transactions. The Government of Hong Kong periodically conducts a comprehensive risk assessment examining MLTF threats facing Hong Kong and its business sectors and industries, and the enhanced ways in addressing these threats by individual sectors. In July this year, Hong Kong published the MLTF Risk Assessment Report. The report represents the findings of Hong Kong's risk assessment completed in 2021. It includes detailed discussion of developments from the emergence of new financial services to changes in types of MLTF activities and the adoption of rules and techniques to prevent related crime. The report also includes Hong Kong's first assessment of proliferation financing risk. The relevant part relating to moneylenders is contained in paragraph 5.8 of Chapter 5 of the report under the topic of sectorial risk assessment of financial institutions. The report states that loan sharking and fraud with the use of false documents to prove regular salary income for applying loans and settling the loans in a short period of time are major ML threats in the money lending sector. The overall ML risk for money lender sector is assessed as medium-low. The major legislation and guideline, which is relevant to AML-CFT, includes the AML guideline that I have mentioned earlier. It contains detailed explanation of the customer due diligence measures and the record-keeping requirements of the licensed moneylenders. Licensed moneylenders are also required to comply with legislation relating to financial sanctions, terrorist financing, and proliferation financing of weapons of mass destruction, and to report suspicious transactions to the Joint Financial Intelligence Unit, the JFIU. Chapter 5 of the AML guideline explains about the requirements on customer due diligence, the CDD. The CDD measures include identifying the customer and verifying the customer's identity, identifying and taking reasonable measures to verify the beneficial owner's identity, obtaining information on the purpose and intended nature of business relationship established with the licensee. If a person purports to act on behalf of the customer, identifying the person and taking reasonable measures to verify the person's identity and verifying the person's authority to act on behalf of the customer. So, under what circumstances would a licensee be required to apply CDD? Paragraph 5.4 of the AML guideline provides the following 4 scenarios. Number 1, before establishing a business relationship with the customer. Number 2, before carrying out for the customer an occasional transaction that involves an amount equal to or exceeding an aggregate value of 120,000 Hong Kong dollars. Number 3, when the licensee suspects that the customer or the customer's account is involved in AML or TF. And lastly, when the licensee doubts the veracity or adequacy of any information previously obtained for the purpose of identifying the customer or verifying the customer's identity. When the licensee is unable to complete the CDD process, it must not establish a business relationship or carry out any occasional transaction with that customer, and should assess whether this failure provides grounds for knowledge or suspicion for MLTF and filing an STR with the JFRU. Paragraph 5.25 of the AML guideline states some high-risk situations for which enhanced due diligence, that is the EDD, should apply. For example, customer not physically present for identification purposes, customer or its beneficial owner being a politically exposed person, corporate customer which has issued bearer shares, or customers from or transaction connected with a jurisdiction that does not adopt or insufficiently adopts the FATF recommendations. In the case where a customer has not been physically present for identification purposes, at least one of the following measures must be carried out. Further verifying the customer's identity on the basis of documents, data, or information not previously used for the purpose of verification of the customer's identity, or taking supplementary measures to verify information relating to the customer that has been obtained by the licensee, or ensuring that the first payment made into the customer's account is received from an account in the customer's name with an authorized institution or bank operating in an equivalent jurisdiction that has measures in place to ensure compliance with the AML, that is Cap 615, and is supervised for compliance with those requirements by a banking regulator in that jurisdiction. Also, if a customer or the beneficial owner is a PEP, licensees must apply EDD measures, which include obtaining approval from the senior management, taking reasonable measures to establish the customer's or the beneficial owner's source of wealth and the source of funds, applying enhanced monitoring in accordance with the assessed risk. Regarding the record-keeping requirements, paragraph 9.3 of the AML guideline stipulates what records should be kept and for how long they should be kept. For each customer, records should be kept throughout the continuance of the business relationship with the customer, and for at least 5 years after the end of the business relationship. Records that should be kept include all documents and record of the data and information obtained in the course of identifying and verifying the customer or the beneficial owner, and the records relating to the nature of the business relationship, and also the files relating to the customer's business relationship and business correspondence with the customer or the beneficial owner. In respect of each transaction, the original or copy of the documents and records obtained in connection with the transaction should be kept, and they should be kept for at least 5 years after completion of the transaction, regardless of whether the business relationship ends during that period. According to the recommendations under the Mutual Evaluation Report issued by the FATF, we have amended the AML guideline in September 2021. The amendments cover two areas, which include independent audit function and tipping off. For independent audit function, paragraphs 3.9 to 3.11 have been added to the AML guideline to require licensees to establish an independent audit function. The function should have a direct line of communication to their senior management and should have sufficient expertise and resources to enable the licensee to carry out its responsibilities. The audit function should regularly review the AML CFT systems to ensure effectiveness. For example, the adequacy of the licensee's AML CFT systems, the effectiveness of suspicious transaction reporting systems, and the level of awareness of staff having AML CFT responsibilities. The frequency and extent of the review should be commensurate with the nature, size, and complexity of the licensee's businesses and the MLTF risk arising from those businesses. And where appropriate, the licensee should also seek a review from external parties. Regarding tipping off, we have added paragraph 6.9 to the AML guideline to remind licensees that making inquiries to customers, when conducted properly and in good faith, will not constitute tipping off. However, if the licensee reasonably believes that performing the CDD process will tip off the customer, it may stop pursuing the process. The licensee should document the basis for its assessment and also file an STR to the JFRU as appropriate. I will now briefly talk about the legislation in relation to financial sanctions and terrorist financing. According to the United Nations Sanctions Ordinance, that is CAP 537, the Chief Executive shall make regulations to implement sanctions, including targeted financial sanctions against certain persons and entities designated by the Security Council of the United Nations. It is an offense for any person to make available or deal with economic assets of individuals or entities designated by the United Nations Security Council, or those acting on behalf of, or at the direction of, or owned or controlled by such individuals or entities. Offenders will be subject to a maximum sentence of 7 years imprisonment and a fine. Regarding terrorist financing, the UNATMO, that is the CAP 575, prohibits the provision or collection of property and making any property or financial services available to terrorists or terrorist associates. Offenders will be subject to a maximum penalty of 14 years imprisonment and a fine. Licensees are reminded not to have any business relationship with any sanctioned individuals or entities, or any terrorist or terrorist associate as defined under the UNATMO. For details, you may refer to Chapter 8 of the AML guideline. Comprehensive ongoing screening of a licensee's complete customer base is a fundamental internal control to prevent terrorist financing and sanction violations. Licensees should have an appropriate system to conduct name checks against the relevant lists for screening purposes, and that the lists are up to date. List of sanctioned persons and entities and list of names of persons designated as terrorist or terrorist associates specified under the UNATMO are available at our website. Regarding counter-financing of proliferation of weapons of mass destruction, these are the relevant regulations, including CAP 537AE and CAP 537BV. Under Section 4 of the Weapons of Mass Destruction, Control of or Provision of Services Ordinance, the CAP 526, it is an offense for a person to provide any services where he or she believes or suspects on reasonable grounds that those services may be connected to weapon of mass destruction proliferation. The provision of services covers a wide range of activities, and it includes the lending of money or other provision of financial assistance. According to CAP 405 and CAP 455, it is an offense if a person fails to disclose to an authorized officer, that is the JFRU, where the person knows or suspects that property represents the proceeds of drug trafficking or an indictable offense. Likewise, according to Section 12 of the UNATMO, it is an offense to fail to disclose knowledge of suspicion of terrorist property. Offenders will be subject to a maximum penalty of 3 months imprisonment and a fine of 50,000 Hong Kong dollars. In case of suspicions of money laundering, terrorist financing, proliferation financing, or sanctions violations, report shall be made to the JFRU. For details, you may refer to Chapter 7 of the AML guideline. For further details of this seminar, you may also visit the dedicated web page on AML CTF in the website of the company's registry, www.cr.gov.hk. This ends my part for this seminar. Thank you very much.